An overview of Factories Act 1948. The central government has passed 4 bills on labor codes between 2019 and 2020. The 4 labor codes are Code on Wages, Industrial Relations Code, Social Security Code, and Occupational Safety, Health and Working Conditions Code. The 4 labor codes are set to consolidate and replace 29 labor laws as existing now. The rules for all the 4 codes are awaited for early finalization and implementation. A factory, as covered under the Act, is a premises including precincts at which on any day during the last 12 months a manufacturing process carried on with power and 10 or more workers or without power and 20 or more workers, and state government can make rules on approval, licensing and registration of a factory. A manufacturing process involves making, altering, repairing, finishing, packing or washing, cleaning, demolishing or treating any article or substance with a view to its use, sale, transport, delivery or disposal, and it includes transmission of power, pumping of oil, sewerage, printing, cold storage, shipbuilding and such other activities. A worker under the Act is anyone who is employed in a manufacturing process or in cleaning any part of the machinery or premises of a process. He might be directly or indirectly recruited for a remuneration or otherwise, with or without the knowledge of the principal employer. The Act specifies under cleanliness every factory to be kept clean with the removal of dirt, refuse from floors, floor wash and proper water drainage, whitewash every 14 months and painting every 5 years with the proper records maintained for the periodicity of painting, whitewash and the related things. The Act covers the origins of dust and fume to be properly covered with the exhaust appliances, with arrangements made to enclose such points, clean and hygienic spittoons, properly maintained, ventilated and lighted toilets, conveniently accessible to workers at all times. Suitable and sufficient lighting including skylights, prevention of glare and shadow to protect from accidents, wholesome drinking water points sufficient, accessible and hygienic, being away by a minimum of 6 meters from urinals, latrines, spittoons and washing places. The Act prescribes proper ventilation to ensure circulation of fresh air, insulation of hot spots to separate temperature from the work process, along with the allotment of specified space for each worker to avoid overcrowding, and artificially regulating the humidity of air at workplaces. For any factory involving an hazardous process, either for setting up or for expansion, government approval is required to be obtained. An appraisal committee appointed by the government will review every application and give its recommendation to the government within a period of 90 days from the date of application. A hazardous process refers to any process or activity in relation to an industry specified in the first schedule to the Act, wherein unless special care is taken, the raw materials, byproducts or wastes of the process are likely to cause material impairment to the health of persons engaged, and they are also likely to pollute general environment. As regards obligations of occupier on hazardous substances, disclose dangers and hazards to workers and implement measures to overcome such hazards. Lay down procedures for handling, usage, storage and disposal of such substances. have emergency and disaster control plan for employees and people in the vicinity, have fire precaution systems and proper safety officers, and above all, publicize the measures among employees and public. Occupier is responsible for safety of workers with proper measures on fencing of machinery and special care in respect of lifting machines, revolving machines and self-acting machines, highlighting devices for cutting off power, protection of eyes from fumes and gases and proper coverage of sump openings. The occupier under the Act is one who has the ultimate control over the affairs of the factory. He can be a partner, director or one who manages affairs of the company. He needs to send to Chief Inspector a notice before using any premises with the details of the location, nature of manufacturing process, detail of workers. And he shall ensure health, safety and welfare of every worker in the factory. As regards employment of women, not more than 9 hours a day of work and working hours strictly between 6 a.m. and 7 p.m. It gives liberty for the state government to prescribe relaxation between 10 p.m. and 5 a.m. Any change of shift can be only after a weekly holiday, and on dangerous machines, no women can be allowed to work. The Act prohibits employment of children who have not completed 14 years of age. A child worker must be above 14 years of age and carry certificate of fitness on the person. A female child worker can work only between 8 a.m. and 7 p.m. Per day, hours of work cannot exceed 4.5, and child worker can work only in 2 shifts, and the spread in each shift should not be more than 5 hours. A certifying surgeon issues the certificate of fitness to the child worker and it will be valid for 12 months. And it is issued against an application by the candidate along with the employment proposal from the factory, and the certifying surgeon's fee is borne by the factory or the occupant. And the certifying surgeon may revoke any time the certificate of fitness for valid reasons. Certifying surgeons are qualified medical practitioners appointed by state government. They are appointed for a specific factory or a class of factories or for a locality, and their functions include examination and certification of young persons and examination of persons engaged in factories involving dangerous occupations and processes, and exercising such medical supervision as may be prescribed for any factory or factories by the government. The Act mandates the factory manager to maintain a register of child workers detailing name and nature of work, the group in which the child is included, if in shifts the relay to which he is allotted, and his certificate of fitness number and date. The Act provides for clean and adequate change rooms with facilities to store clothes that are not worn during working hours, and it also specifies screened areas separately for men and women workers. The Act provides for sitting facilities for those workers who, as a part of the job, are required to be in standing position in the course of work, and it also mandates maintenance of first aid appliances and facilities under the control of a person holding certificate in first aid treatment. In a factory where more than 250 workers are there, canteens are required to be set up either directly or through contractors. The running expenses of canteens should not be passed on to workers. And the Act also provides for maintenance of restrooms and lunchrooms adequate in size, properly lighted and ventilated, and maintained in a clean and cool condition. Where women employees are more than 30, it is required for the company to maintain creches for workers' children under 6 years under the care of trained women who can take care of children and infants. And where the number of workers employed is more than 500, it is required to have adequate number of welfare officers as prescribed. The permitted working hours for an adult is 9 hours a day and a stretch of work with rest interval not to exceed 5 hours in a day, including the rest interval. Total working hours not to exceed 10.5 hours. In a week, working hours allowed are 48 hours and the name, nature of work and shift allowed will be specified in the register of adult workers as required. One of the 3 days before or after the first day of every week must be a holiday. If there is a change in the holiday, inspector has to be informed and it has to be displayed in the factory. Where a weekly holiday is deprived, it has to be allowed in the same month or within 2 months. And the holiday period means a period of 24 hours from the end of shift. A worker, if he is already working in a factory, he is prohibited from concurrently working in another factory. The Act prohibits double employment. Overtime wages are payable at twice the ordinary rate of wages, and overtime wages are due for work more than 9 hours a day or more than 48 hours in any week. 240 days in a calendar year required to be worked to be eligible for annual leave. Adults, 1 day for every 20 working days. Children, 1 day for every 15 days is the eligibility in a calendar year. Half a day or more converted into full and less than half ignored. Carry forward, 30 days allowed for adults and 40 days allowed for children. For availing leave, 15 days in advance, one has to submit application to the manager and it cannot be refused except as per scheme. Leave wages are calculated based on daily average earning for the immediately preceding month. If the immediately preceding month doesn't have working days, then it will be taken from the current month for the actual days worked. Leave has to be paid before the leave begins for an adult going on leave for 4 days and above and for a child going on leave for 5 days and above. Any final settlement to be made within 2 working days of discharge, dismissal or quitting, and it shall be made within 2 months of superannuation or death in service. An overview of Employees State Insurance Act. The object of ESI Act is to provide benefits to employees in case of sickness, maternity and employment injury. The Act applies to all factories other than seasonal factories. Factory means any premises including precincts thereof where 10 or more persons employed on any day during the last 12 months and in any part of which a manufacturing process is carried on. The Act continues to apply if the number of employees falls below the limit specified. Seasonal factory, which is outside the scope of ESI, is one which is engaged in one or more of manufacturing processes, namely cotton ginning, cotton or jute processing, decortification of groundnuts, manufacture of coffee, rubber, sugar or tea, or any manufacturing process connected with any one of the above, and it also includes a factory which is engaged for a period not exceeding 7 months in a year. An insured person is an employee. He contributes to the ESI fund and for that reason he becomes eligible for benefits provided by the Act. An upper ceiling of rupees 21,000 per month is fixed as wage for coverage under ESI. If the wages exceeds 21,000 after the commencement of contribution period, the employee shall continue to be covered till the end of the contribution period and then he will be excluded. The concept wages means remuneration payable to an employee as per contract. It includes even payment for leave, strike period, lockout or layoff, but it doesn't include any PF contribution by employer, traveling concession or traveling allowance, and any reimbursements of expenses and gratuity payable on discharge. Briefly, it includes basic DA, CCA, HRA, incentive and any allowances. Employee is a person employed in connection with the work of a factory or establishment. He may be employed by the principal employer directly, or he may be hired through an immediate employer, but he works on the premises or elsewhere under the supervision of the principal employer or his agent. And it also includes one whose services are let on hire to principal employer on a contract of service by the immediate employer. In relation to a factory, principal employer means the owner, occupier or his agent, a manager or managing director, or it includes legal representative of a deceased owner or occupier. As related to any other establishment, principal employer means the person who has the ultimate control over the affairs of the establishment. It includes a manager or a managing director. Immediate employer refers to a contractor who has undertaken on the premises of the principal employer certain works which is a part of the work of the factory or establishment, and he works under the supervision of the principal employer or his agent. Or an immediate employer may also provide people on hire at the service of the principal employer. Occupier is the person who has ultimate control over the affairs of the factory or establishment. It includes an employer, manager, executive manager, CEO, or any other person having ultimate control on the factory or establishment. As occupier, he is responsible for coverage of ESI for all people who are a part of the factory of establishment, directly employed or indirectly employed, as held in case of Royal Talkies Hyderabad, where even the employees of canteen and cycle stand run by external contractors and operators was held to be responsibility of the owner of the cinema talkies. All contributions received under the Act are deposited into the ESI fund. The ESI fund is administered by the ESI Corporation. ESI fund can accept grants, donations, gifts, etc. from government, local authority, individual or body corporate. ESI fund takes care of the benefits and medical treatment of insured persons and their families. It also covers the fees and allowances of members of the corporation, committees and councils. The fund takes care of employee related expenses of the setup, and it is the main source for establishment and maintenance of hospitals, dispensaries and other institutions. And it also takes care of contributions towards cost of medical treatment and other purposes as authorized from time to time. ESI contribution has two components: employer's contribution and employee's contribution. The principal employer is responsible to collect from the employee and remit it together with his contribution. And the contribution from the employer is 3.25% of workers' wages, while the contribution of an employee is 0.75%. For payment of ESI contribution, the principal employer has got time up to 21 days after the end of the calendar month in which the wage falls due. An employment injury is a personal injury caused by accident or an occupational disease, but the requirement is it should arise out of and in the course of his employment. It might occur or be contracted anywhere within India or outside India. Temporary disablement is a condition resulting from an employment injury which requires medical treatment, and as a result, the employee is rendered temporarily incapable of doing what he was doing prior to the injury. Permanent partial disablement is a disablement of a permanent nature. It reduces the earning capacity of an employee in every employment which he was capable of undertaking prior to the accident resulting in the disablement. It is listed in Part 2 of Schedule 2 among injuries deemed to result in permanent partial disablement. Permanent total disablement is a disablement of a permanent nature which incapacitates an employee for all work which he was capable of performing at the time of the accident. It is listed in Part 1 of Schedule 2. Loss of both hands, loss of a hand and a foot, absolute deafness are examples of permanent total disablement. Even injuries listed in Part 2 can result in permanent total disablement when the combination of injuries aggregate to a loss of 100% or more. Sickness benefit from ESI as a periodical payment is made available to the insured person based on a certificate from a duly appointed medical practitioner. Maternity benefit in the form of periodical payments to an insured woman based on certification to that effect in respect of confinement or miscarriage, or sickness arising out of pregnancy, confinement, premature birth of child or miscarriage. ESI disablement benefit available to an insured person as a periodical payment towards disablement resulting from an employment injury, duly certified for eligibility. Medical attendance and medical treatment of insured persons is a part of medical benefit. Even the family members of the insured persons are covered provided there is an approval from the appropriate government. The definition of family for medical benefit is quite comprehensive. It includes the relatives of an insured person like spouse, unmarried daughter, dependent parents, a child who is infirm and is wholly dependent on the insured person, a minor child till attains the age of 21 years, and where parents of the insured are not alive, a wholly dependent minor brother or sister also forms a part of family. ESI makes available dependents benefit as a periodical payment to dependents on the death of an insured person as a result of an employment injury. Dependent includes relatives of a deceased insured person comprising widow, minor son, an unmarried daughter, a parent or a widowed mother, a son or daughter who is infirm, a minor brother or an unmarried sister if no parent is alive, or a widowed daughter-in-law, and a minor child of a predeceased son or daughter or a paternal grandparent if no parent is alive. On the death of an insured person, payment is made towards expenditure on the funeral, and it is normally paid to the eldest surviving member of the family of the insured person who has died, or to one who has actually incurred the funeral expenses. Three types of treatment available to an insured person: as an outpatient or by visits to the home of an insured person or as an inpatient. The only condition is during the period contributions are required to be payable and the insured person must be entitled to medical benefit as per regulations. In respect of an insured person who is under permanent disablement, the medical benefit will continue till such time he would have otherwise attained the age of superannuation. The only requirement is the payment of contribution must continue during the period. ESI medical benefit can also be available after superannuation provided there is continued payment of contributions and the benefit is available to an insured person who has attained the age of superannuation and his spouse, and also to an insured person who retires under a voluntary retirement scheme and it is available to his spouse too. ESI insists that the insured person and his family shall avail medical treatment as provided by the corporation at the prescribed hospitals, dispensaries and clinics, and ESI corporation doesn't entertain any reimbursement of expenses. ESI prohibits clubbing of benefits. An insured person cannot receive for the same period both sickness benefit and maternity benefit together, or sickness benefit and disablement benefit. Similarly, maternity benefit and disablement benefit. It is required that the insured person must make a choice between the available benefits and opt for only one of them. Any benefit under the Act is neither transferable nor assignable, and any cash benefit under the Act shall not be liable to be attached under a court order or sold in execution of any decree or order of the court. Any benefit received without lawful entitlement is required to be repaid, else it is liable to be recovered as an arrear of land revenue. When a person is entitled to ESI benefit, he is prohibited from taking any similar benefit admissible under any other enactment. ESI court is set up for each local area by the state government. It deals with the scope, applicability, concepts, rates and other matters which are in dispute. It has powers of a civil court for enforcing attendance, production of documents and recording evidence. Order of such a court is enforceable as if it were a decree passed in a suit by a civil court. No appeal lies against the order of an ESI court except to High Court on substantial question of law, and the appeal can be submitted within 60 days. ESI contribution remaining unpaid can be recovered as an arrear of land revenue. An authorized officer can issue a certificate for the amount addressed to the recovery officer, and the recovery officer is authorized to recover the certified amount from the factory or establishment by attachment and sale of its movable or immovable property, or by appointing a receiver for the management of the properties of. ESI is a preferential creditor as in the distribution of assets of a company being wound up. Dues to the corporation are to be paid in priority to all other debts. The Act prohibits an employer using the liability for contributions payable under the Act as the ground for reducing the wages of an employee, and also from discontinuing or reducing benefits payable under the conditions of service. The Act prohibits any dismissal or punishment to an insured person During the period, the employee is in receipt of sickness benefit, maternity benefit or disablement benefit, or is under medical treatment for sickness, or is absent for work as a result of illness which is duly certified.